Good afternoon, everyone. Good morning from my side and those who are on my side of the world. My name is Zachary Phillips. I am a Crown Counsel from Antigua and Barbuda, and I'm honored to be invited to join this panel today. Um, I'll start by indicating a bit of my background, which will give some of the context as to what I will say today. In my capacity as a Crown Counsel, I work in the Attorney General's Office of Antigua and Barbuda. So, as Antigua and Barbuda is one of the states that founded the Commission of Small Island States, that meant that some of our government resources were also involved in preparing the request for an advisory opinion from the International Tribunal on the Law of the Sea. And by government resources, I mean myself and another member of staff in Antigua and Barbuda. So through this capacity, I've participated in the ITLOS advisory opinion. I've also participated in the Inter-American advisory opinion, and in the ICJM also will be participating when those oral proceedings commence. So I say that to say I see a lot of familiar faces both on the panel and within the room, and I am very, very excited to be a part of this panel, particularly because of the question or the title, Old Principles, New Standards. Because as some of the speakers have said, it is a very apt discussion to be having, particularly at this time frame with all the advisory opinions that are occurring. But I would also add, particularly in relation to our next set of NDCs that would be required under the Paris Agreements. I forgot to mention, I'm also part of the national delegation for negotiating within the UNFCCC framework. So my presentation, I purposely did not bring slides because I thought it may be useful to have a discussion on what could this new standards look like for small island developing states. And I was thinking, as I was trying to answer the questions of what would a future look like, what is the future that SIDS want to see, I found creating those answers and lodging them specifically within principles of international law was a bit difficult. So I thought the best way to discuss this and engage in this morning would be to pose the questions to the audience, but allow for enough of an examination of the principles as they exist now, along with some practical experience that I've gained in my capacity working for the government. So with that being said, you cannot see my office, but I do have a very large whiteboard with a lot of different notes, and I will try my best to make my thoughts as coherent as possible as we continue for the next 20 minutes. So in discussing these old principles and new standards, my hope is to discuss the principle of common but differentiated responsibilities, due diligence, and the precautionary principle, and intertwine some real-life examples of difficulties that we have as small island states, both with governance and with compliance with international obligations. And then in seeing those examples, I'd also highlight what the ITLOS advisory opinion has added and what possibilities may result from those additions. So let's start with common but differentiated responsibility. So using this example, in the different panel discussions that I have done, trying to plead the case for SIDS to see why exactly our situations are so unique and so daunting when it comes to international obligations and, well, the climate crisis generally. I usually give the example that the country that I am from, Antigua and Barbuda, is 170 square miles. The landmass is 170 square miles. However, our exclusive economic zone is 42,506 square miles. And for a term of reference, this is roughly the same size as the state of New York, not New York City, New York State. So as it is right now, given our traditional understanding of the exclusive economic zone and prevention of pollution, it is extremely difficult for the 100,000 people who live in Antigua and Barbuda and the even smaller civil service to properly regulate and monitor all of our exclusive economic zone to make sure that not a single drop of pollution enters the oceans. So even as it is right now, when we're looking at the traditional definition of pollution, there is assistance that is needed from international partners, whether it be multilaterally, whether it be bilaterally, in order for us to upkeep our obligations. But as noted in the ITLOS advisory opinion, the definition of pollution has been extended or interpreted, whichever phrase you wish to use, to include GHG emissions. So can you imagine the difficulty that exists now for a small island developing state to monitor our traditional idea of what pollution is, has now been expanded to include emissions from the air, and the capacity which we had already, which was constrained to begin with. It therefore means that the support, the technical capacity, the assistance, all of that which we understand to be part and parcel of what it means, what the phrase common but differentiated responsibility means, must be further amplified and exemplified to support small island states like my own in their I'd hesitate to use the word basic, but in their the basic obligations of protecting their EEZ. Now, I've only highlighted one example of what needs to be regulated and monitored within the EEZ for the examples of the difficulty of how monumental a task it is from a small island developing state. But on the inverse, we also note that there are a lot of states that have more capacity to do this sort of protection, but may have a smaller EEZ, or they may have an EEZ that is more in line with the size of Antigua and Barbuda, but may also have far larger capacity to protect their own space as well as other spaces. Now, I started this example by using the traditional understanding of pollution, but if we're taking it with a climate change context, there obviously includes some nuances that wouldn't necessarily be solved by the global north sending an additional 5 ships to patrol the waters of Antigua and Barbuda. So we do accept and understand, and I believe it's built into this entire conference, that this is a multidisciplinary, multi-problematic area, but highlighting again, the constraints that SIDS have is triple-folded or 10-folded given our limited capacity. Now, with that example, I'd like to point out that the ITLOS advisory opinion has spoken to the fact that states parties have specific obligation to assist developing states, in particular, vulnerable developing states in their efforts to address marine pollution from anthropogenic GHG emissions. Additionally, according to the opinion, measures of adaptation and resilience building frequently require significant resources. So that is a point to keep as we continue our journey and discuss the other 2 principles of due diligence and precautionary principle. So with due diligence, this is generally referred to all necessary measures that are to be done by the state in order to comply with their obligations. I think our first speaker, Professor Brune, has done an excellent job of outlining the developments over time. So in the interest of time, I think I will skip that discussion about what due diligence is and rather focus on what the ITLOS advisory opinion has said about due diligence and how they have added. So the primary takeaway, and I believe the most novel takeaway that we've received from this advisory opinion, is the specific and direct link of the importance of the best available science in relation to states' obligations. So with that in mind, since due diligence obligations are the more risky the potential harm, the more strict it needs to be, the due diligence is both substantive and a procedural obligation at the same time, it indicates that this science, this scientific input, this scientific impetus into what states are supposed to do to meet their obligations must be one that survives the rigors, survives the rigors of different scientific tests. So we know that the best available science, at least coming from the UNFCCC context, would be the IPCC, as those reports are what are agreed upon as the science that informs climate change and climate change action. But with that in mind, I pose questions to you who are here at the conference, is that in my preparation for the different advisory opinions, I have seen and I myself have read certain arguments that relay or try and equate this idea to a global carbon budget, because the science is not limited by issues of political territory or territorial sovereignty or geopolitics. The science is just speaking to what needs to be done in order for the climate action to actually make a difference, a tangible difference, that we do not end up on a 1.5 track or a 2 degrees Celsius track. So if the science is being informed with an absence of geopolitical, or I should say national division, let me phrase it that way in a more neutral term, then does that not also raise the question, which I myself do not have an answer to, that perhaps the science should inform actions that would speak to more than just your territorial sovereignty? And by that, I'm literally have seen arguments made in some of the advisory opinion submissions that perhaps our next sets of NDCs, states that have more capacity, should consider how exactly their actions will affect other states that have less capacity. So for example, relying on that initial example that I gave with the exclusive economic zone and the sheer size of Antigua and Barbuda compared to the landmass, perhaps there's questions that can be asked on whether or not NDCs should look more so at a global percentage of the carbon budget as opposed to what your state is emitting on its own and what you can regulate specifically within the context of your state. Because if the NDCs of the world are not seen in the context of an entire mosaic, and we look at the pieces of the puzzle together to solve one big picture, then unfortunately, we will never reach the goal that we are intended to reach. With that being said, I note again the comments of the ITLOS advisory opinion that I believe, depending on who is the negotiator in the room or who is the lawyer before the different tribunals, an argument can be stretched, and I accept fully that it would be a stretch. But let's hear what the language says. The ITLOS advisory opinion has said the standard of due diligence has to be more severe for the riskier activities. The notion of risk should be appreciated both in terms of probability and foreseeability of the occurrence of harm, and the severity or the magnitude. Very important. They've also said, in light of such information, the tribunal considers that the standard of due diligence states must exercise in relation to marine pollution from anthropogenic GHG emissions needs to be stringent. And we already had a great explanation of what that stringent nature looks like, thanks to our first speaker. They went on further to say that an obligation of due diligence should not be understood as an obligation which depends largely on the discretion of a state or necessarily requires a lesser degree of effort to achieve the intended results. The content of an obligation of due diligence should be determined objectively under the circumstances, taking into account relevant factors. In many instances, an obligation of due diligence can be highly demanding. So the question here really is, what is the ambit and the scope of relevant factors that need to be taken into account? And as I said again, there are many persons more learned than I, but a potential question that can be digested over the next couple of days is, can we consider a global problem and a global solution should other states other than your own be part of the relevant considerations as we head into the NDCs of 2025? Now that ties to the precautionary principle. As we all know, due diligence and the precautionary principle are intertwined. And the ITLOS advisory opinion confirms that by saying at paragraph 242, the obligation of due diligence is closely linked with the precautionary approach. Therefore, states would not meet their obligation of due diligence under Article 194, paragraph 1, if they disregard or did not adequately account for the risk involved in the activities under their jurisdiction or control. Now I go further, and again, leaning on the discussions that we've already had in this panel, to say that surely the rule of prevention of harm and transboundary harm must play a role when a state is deciding what are their obligations as it relates to due diligence and how they truly comply with the precautionary approach / principle. So with that in mind, takes me to an example that would have been discussed during the chairmanship of Antigua of the Alliance of Small Island States, where Antigua was chair in 2022. And a discussion was severely, I could say it was a very hard discussion amongst SIDS themselves, because we were looking at the future viability of our nations. And the Pacific region is home to more than most of the world's tuna population. So in relation to that, my question that I'm posing to the room is, if the certainty of science is not necessary in order to make sure that your actions are compliant with due diligence, but what you should really be concerned about is the assessment of the risk, what do we say for those situations where, for example, in the Pacific, there is a real and viable situation where a permanent loss of 80% of their revenue, being the transboundary stocks of tuna travel between their waters, may be lost as a result of the climate crisis? Now, to give specific statistics, there's an organization called the Parties to the Nauru Agreement, which is made of 8 Pacific small island developing states. And amongst them, tuna revenue generates $5 million USD for each of those states, and 80% of the revenue for each of those states. Now, if as a result of warming seas, as a result of ocean acidification, the tuna no longer passes through their EEZs, what does that mean as it relates to their viability going forward? What does that mean as it relates to their way of life? Now, that is a social aspect, but let's look back at what we've just discussed from the legal point of view. We've already said that the greater the risk, the more that there should be a stringent action as it relates to due diligence. We've already said common but differentiated responsibilities means that those states that are able to do more should in fact do more and assist those states who cannot do more. And we've already said that the precautionary principle ties into due diligence standards, as well as both of these are linked to the principle of common but differentiated responsibilities. So again, I say, I do not have the answer, but is this a scenario that perhaps warrants further discussion or further consideration for specifically those particularly vulnerable states, which may result in a situation where not only are ecosystems permanently lost, but the economic indicators or revenue from those ecosystems will also be permanently affected. What does international law have to say about that? And with that very heavy question, admittedly, I think I will stop here and allow our next speaker to continue. Thank you very much.